Ever had one of your videos or podcast episodes just vanish overnight? No warning, no explanation, it's just gone. You've probably been hit with a DMCA takedown. Hey, I'm Gordon Firemark, the podcast lawyer, and today I'm unpacking how the Digital Millennium Copyright Act, or the DMCA, really works. What happens when you get a takedown notice, what a counter notice actually does, and why filing one can be both your best defense and your biggest risk. The DMCA is a U.S. law that helps copyright owners protect their work online. It also gives platforms like YouTube and Spotify a safe harbor from liability, as long as they follow the DMCA's notice and takedown rules. When a copyright holder claims their work's been used without permission, the platform must act quickly and remove the content. That's the takedown part. A takedown notice has to include specific information: who owns the work, where it's being used, and a sworn statement that the claim is being made in good faith. Once that notice hits the platform, your content can be taken down immediately, even before you get a chance to respond. Now, if you believe that the takedown was wrong, maybe your use qualifies as fair use or you had permission, well, then you can send a counter notice. That's your formal statement saying, I have a legal right to post this content. And if your counter notice checks all the legal boxes, the platform has to notify the claimant and then wait 10 to 14 business days before restoring your content. But here's the part that most people don't realize. Filing a counter notice can trigger a lawsuit. That 10 to 14 day window exists to give the claimant time to decide whether to sue you in federal court. If they do, your content stays down until the case is resolved. If they don't file suit within that window, the platform has to then restore your content. But that doesn't mean they can't still sue you. But before you file a counter notice, it's a good idea to just make sure you're ready and willing to defend your position, because you might be inviting a legal battle. Now, if you operate a website, a podcast network, or any kind of platform where your users upload content, then you need to register a DMCA agent with the U.S. Copyright Office. That's the official contact name and address and person for takedown notices. If you don't register, you could lose that safe harbor and be personally liable for what others post on your site. Registration only takes a few minutes online, and the filing fee is minimal, like $6, a lot cheaper than facing a copyright claim without protection. So to recap, takedown notices remove the content fast, sometimes automatically. Counter notices can get your content restored, but they can also provoke a lawsuit, so should be used carefully. And registering a DMCA agent protects your platform from liability. If you need to send a DMCA takedown or respond to one, don't wing it. And don't rely on random internet templates. Get the exact properly worded DMCA takedown demand or counter notice template I use in my law practice, complete with step-by-step video instructions. It's all available at podcastlawforums.com. That's how you handle DMCA issues the right way: confidently, professionally, and without expensive legal fees.